We want to thank you. We want to thank all of you very much for being here. Before I start my remarks, I want to say thank you to all the former clerks of the judge who are here to express their views of why he should be on the United States Supreme Court. And I just got done telling them that this is a news conference where they are more important than us senators are, from this standpoint that they have, day in and day out, know the qualifications of this person to be on the Supreme Court. Last week, the Judiciary Committee saw a brilliant display from the Supreme Court nominee, the Judge Neil Gorsuch. Most importantly, he showed a command of the law and an independence from outside influence. My Judiciary Committee colleagues, those of us here and others, saw what the judge's clerks already know. The judge has an incredible legal mind and a humility that keeps him well grounded. He's easily cleared every hurdle in front of him for this position. It leaves me then very stunned why there's this talk about a filibuster. It's quite clear that if he isn't qualified, then nobody is. And if you'd be filibustering a judge like this, it's obviously that you'd filibuster anyone. So, the actions by those who want to filibuster is quite purely politics. Because if you're voting on his qualifications, it's a very easy yes vote. We're joined today, as I've previously said, by a number of the judges' clerks. I've not seen anything like that in all the years that I've been involved, and it's a wonderful display of what these people have been doing, not only here with us today, but other places and in different venues around the country to support the judge. They are accomplished lawyers in their own right. Their fierce loyalty to the judge says a lot about the type of person that we're going to have on the Supreme Court. They know him better than most. They know the fair-minded approach that he will bring to the court. And I think they'd agree with one of the judge's colleagues who wrote this, quote, "I'm not sure that we could expect better, or that better presently exists." We're glad to have so many here today. And with that, I turn to my colleagues, starting with Senator Graham.
Thank you, Mr. Chairman. Thank you for the way you run the committee. I represent all the lawyers who could not become Supreme Court clerks because we're not smart enough, but there are more of us than there are of you. So I've practiced law most of my adult life, and I enjoy the law. I like politics, but I have a particular passion for the law. And I want to congratulate President Trump for nominating Neil Gorsuch. There was no better qualified person that he could have chosen to represent filling Justice Scalia's seat. He is a conservative jurist for 10 and a half years. He's exercised the demeanor appropriate with being on the Supreme Court, the intellect appropriate with being on the Supreme Court, the character that is appropriate to be on the Supreme Court. 2,700 cases decided as a circuit court judge with one reversal. So I'm here to tell you he's going to be on the Supreme Court because he's earned the right to be there. The only question is how, it's not even when. To my Democratic colleagues, if he can't get 60 votes, Neil Gorsuch, that tells me that you don't care about qualifications any longer. I voted for Sotomayor and Kagan under the Obama administration. I would not have chosen either one, but I thought they were well qualified. And I can say without hesitation, according to the American Bar Association, Neil Gorsuch is one of the most qualified people in the country to be on the Supreme Court. If you don't believe me, look at the ABA report. 900 pages, 500 people interviewed, law clerks, lawyers, judges, all those who have served with Mr. Gorsuch for a long period of time, and they came to the conclusion that he was well qualified, the highest rating. So as to Judge Garland, incredibly qualified man. He was a victim of nothing other than the Biden rule. In 1992, Joe Biden told President Bush 41, if somebody retires in your last year, don't even send a name up. We'll let the next president decide because the political season is already afoot. That was in June of 1992. Justice Scalia passed away in February of 2016. There had already been 3 primaries in the books. A week after his death with the South Carolina primary, the political season was afoot. We haven't had a replacement like this in 100 years, where you had a president of one party and a senate of another to replace somebody in the last year of a term of a president where there's different parties involved. So Judge Garland is a fine man. He was a victim of nothing more than the president of the Senate and the Biden rule. So that's unpersuasive to me. It has nothing to do with Justice Gorsuch. I really thought that the next president would not be Donald Trump. At the time, I bought into the idea the next president should pick because the political season has started. I just assumed, like most people, that it would probably be a Democrat and it might be more liberal than Garland. President Trump won. He defied my expectations. He won the White House, and he deserves, I believe, the same respect and treatment that was given to President Obama for his 2 nominees that were reported out of committee. I'm asking the Democrats to do no more for President Trump than I did for President Obama. I hope the country understands that if this fine man cannot make it to this building because of what goes on over there, then the problem lies over there. Judge Gorsuch has done everything you could expect a person to do to prepare himself to serve in this building. And the only reason he may not get there with 60 votes is because of the political fear that dominates that building. Thank you very much.
My name is Mike Lee. I'm a senator from the state of Utah, and I'm proud to stand today in support of the nomination of Judge Neil Gorsuch, who I would add is the first Supreme Court nominee in history to have his own choir, from which we've heard just a moment ago. Judge Gorsuch is someone who is uniquely well qualified for the Supreme Court of the United States. As a lawyer who's argued in front of him on the U.S. Court of Appeals for the 10th Circuit where he now sits, I can tell you he's prepared for his arguments. He's read every brief, he's read every opinion, he's read every statute, every case involving the dispute in front of him. And he has one objective, and one objective alone, as his clerks who are assembled here today can attest, and that is to find the right answer under the law. He starts from the standpoint that there is a right answer under the law, and that it's his job as a judge to find out what that answer is. Now, those who have criticized him on a couple of grounds. One of them is they say he's out of the mainstream. Well, this simply isn't supportable, at least if you utilize any conventional metric for what it means to be in the mainstream. Look, the judge, in his decade of service on the U.S. Court of Appeals for the 10th Circuit, has decided about 2,700 cases. In 97% of those cases where he's sat, the decision has been unanimous. He has, in 99% of the cases, at least been in the majority. You have to remember that appellate judges in our federal judiciary don't ever sit alone when hearing appeals. They always serve in panels. Normally a panel of 3 judges, sometimes what we call an en banc panel, which can be a dozen or so judges. But never does this judge sit alone. And so the fact that 99% of the time he's in the majority and 97% his rulings are unanimous really dismisses this idea that he's somehow out of the mainstream. Another one of the criticisms that has come his way has come from those who have said that he somehow doesn't rule for the little guy, that he rules for the big guy instead of the little guy. This, too, is belied by the evidence. This contradicts the evidence itself, and the evidence shows that he's ruled for the little guy over and over and over again. And there's one consistent theme in his rulings. Whether it's the big guy or the little guy who's got the law on his side, Judge Gorsuch is with that party. Those who criticize him for doing this, those who say that he should go out of his way and he should issue a different ruling than what the law requires if there are emotionally compelling circumstances in the case, are ignoring the purpose of a judge. Within our constitutional republic, a judge has a solemn duty to give meaning and effect and due recognition to what the political branches of government have done. It gives due regard for the fact that across the street we have the U.S. Capitol, which is charged with making law within our federal system. It's the judge's job to interpret the law, not to make the law. So what they're saying when they criticize him for not citing the way they want him to cite in an emotionally compelling, emotionally charged case is that they don't want him to be a judge. They want him to be a policymaker. They want him to be a lawmaker. And that his oath to the Constitution will never support. Because Judge Gorsuch is this kind of judge, I support him wholeheartedly. And I look forward in the coming days to making sure he gets confirmed. It's my privilege now to hand the podium over to my friend and colleague, the senator from Texas, Senator Ted Cruz.
Thank you, Mike. Thank you, Mr. Chairman. Welcome. Judge Gorsuch should be confirmed to the Supreme Court, and he will be confirmed to the Supreme Court. On any objective measure, Judge Gorsuch is impeccably well qualified for the court. A graduate of Columbia and Harvard Law School and Oxford, a former law clerk to Justice Byron White, Gorsuch has spent a lifetime in the law, building a record demonstrating that he would make an exemplary justice. The justice for whom he clerked, Byron White, was the only Supreme Court justice appointed by President John F. Kennedy. And anyone who watched the confirmation hearings last week would see a judge who's demonstrated a fidelity to law for a lifetime, despite personal attacks, unfair slights, despite political efforts to appease some of the activists, some of whom are gathered here today. There were no meaningful substantive concerns raised about Judge Gorsuch. Indeed, if this were being decided on the record, Judge Gorsuch would be confirmed 100-0. And we don't have to hypothesize about that, because Judge Gorsuch has been confirmed 100-0. A decade ago, when he was nominated to the Federal Court of Appeals, the Senate confirmed him by voice vote. Not a single senator spoke out against him. Not Dianne Feinstein, not Pat Leahy, not Barack Obama, not Joe Biden, not Hillary Clinton. Every one of them went along with confirming him to the Court of Appeals, a question anyone should ask if they supported his being on the Court of Appeals a decade ago. What's changed? And the only thing that has changed is our energized activist friends that have Democratic senators terrified they will get primaried from the left in a Democratic primary. That's the only thing that's changed. On substance, we now have, in addition to his impeccable qualifications to be a Court of Appeals judge, we have over a decade of proven record on the Court of Appeals and the universal assessment of Judge Gorsuch's tenure as a judge is that he is a judge who follows the law without partiality to any litigant, without partiality to any policy outcome. That's what we want and deserve in judges. A final point. This judicial nomination, I believe, was the most transparent judicial nomination in history. Indeed, it is without precedent. Last year, then-candidate Donald Trump released a list of 21 names from whom he would choose to replace Justice Scalia. The voters had that list in front of them. They knew exactly the 21 names. Neil Gorsuch was one of those 21. Donald Trump promised, if elected, he would nominate a judge in the mold of Justice Scalia. Hillary Clinton, on the other hand, promised a very different kind of justice. She promised a liberal judicial activist who would vote to undermine free speech, to undermine religious liberty, to undermine the Second Amendment right to keep and bear arms. And this election was, in a very real sense, a referendum on the Supreme Court. That has no precedent, the degree to which the voters knew precisely what they were getting. And what I would suggest to you is the overwhelming election result in November, as the American people chose the direction, gives this nomination a kind of super legitimacy It is not simply the president's choice, but it is the president's choice that has been ratified by the American people voting in a national election where they were choosing, do they want a liberal judicial activist or do they want a principled originalist on the court who will protect free speech, protect religious liberty, and protect the Second Amendment? That nomination was ratified by the American people, and next week it will be confirmed by the United States Senate. Thank you.
My name is Leah Bresick. I'm a former clerk to Judge Gorsuch, and I'm speaking on behalf of all of the judges, former clerks, including the clerks standing behind me. The recent hearing before the Senate Judiciary Committee confirmed several things that we, Judge Gorsuch's former clerks, know firsthand. First, there's no question of the judge's intelligence. Throughout the hearing, Judge Gorsuch displayed a profound command of the law and Supreme Court precedent in response to the committee's questions on a breadth of legal topics. Second, there's no question of the judge's temperament. While answering questions into the evening hours over several days, the judge's deep respect for the members of the committee never waned, and his commitment to carefully listen to the points raised before him never faltered. This is the man of integrity and decency that we all know. Third, there's no question of the judge's great respect and empathy for the litigants that appear before him, colleagues on the bench, law professors, former clerks, and friends with political views that span the spectrum, all testified to this before the hearing. The American Bar Association, which gave Judge Gorsuch the strongest endorsement, praised him as respectful, unbiased, and sensitive to the positions of litigants and their counsel. Fourth, there's no question about the judge's independence and impartiality. The hearings have shown that he will not prejudge any issues that may appear before him. He has guaranteed no results, and he is committed to favor no side. The only promise he has made is to keep an open mind and give all arguments full and fair consideration. Judge Gorsuch is a remarkable man and a remarkable judge. We know he will be a justice of whom all Americans would be proud. We hope the Senate takes swift action on his nomination. Thank you.
Questions of any of my colleagues or the clerks? Director.
Former Supreme Court clerk, if you will change the rules in the Senate, that's a big deal, and it's going to affect this place for a long time. Could you talk a little bit why that is necessary now, and whether it's hasty to make such a big step in a traditional place like the Senate?
Yeah, what'd she say?
You're asking about the threshold. Threshold required to close debate to achieve cloture on a nominee. Rule 22 of the Senate rules requires that to close debate, you have 3/5 of the senators sworn and serving. In order to close debate, which you have to do normally in order to get to a final vote. Senate rules can be changed by precedent, and sometimes they are. In November 2013, the then Democratic majority in the Senate chose to take the nuclear option on the executive calendar. They invoked the nuclear option on the executive calendar in order to appeal the ruling of the chair to say that as we were considering some judges to the U.S. Court of Appeals for the D.C. Circuit, that 51 votes rather than 60 should be sufficient. Once precedent is changed, precedent controls. Precedent, in effect, trumps the rule when the precedent is inconsistent with the rule. All of the analysis undertaken at the time for justifying the decision to nuclearize, to go nuclear on the executive calendar, applies with equal force throughout the executive calendar. Although there were some Democratic senators who took to the floor at the time and tried to say, well, we don't intend this to apply in other circumstances, it is applied in every other circumstance ever since then. It is applied with respect to those nominated to cabinet positions, to those nominated to sub-cabinet positions, to people nominated to independent boards and commissions that require Senate confirmation. And it's also applied in the context of life-tenured Article III judges. There is not one argument advanced in justification for the the Democratic Senate majority's decision to go nuclear in November 2013 that doesn't also apply with equal force throughout the executive calendar. There is not one argument that they've made that can apply there. So in my view, that decision was made in November of 2013.
For 200 years, the standard for confirmation of a federal judge in the United States Senate was 51 votes. That is how the Constitution has operated. It's how the Senate has operated for most of this country's history. Indeed, no Supreme Court justice in history has been defeated because he was filibustered. The only arguable example is Abe Fortas, who ultimately withdrew the nomination in the face of a scandal. No justice in history has been filibustered. The notion of filibustering federal judges was largely the invention of Chuck Schumer in 2001 when George W. Bush became president, and Senate Democrats then began unprecedented filibusters of federal judicial nominees. I hope that next week the Democrats do not choose to filibuster Judge Gorsuch, a candidate for whom they voted unanimously just a decade ago. But if they do, I am confident that the Senate will return to the rules that have governed that body for 2 centuries. One of the easiest illustrations of that is to recall the nomination of Justice Clarence Thomas. Justice Clarence Thomas, I believe, has become one of the greatest Supreme Court justices in history, but we all remember that his nomination was highly controversial at the time, that Democrats were very animated, that my friends who are protesting over here were no doubt very animated about Clarence Thomas. And yet Justice Thomas was confirmed with 52 votes. Not a single Democrat demanded a filibuster. Any individual Democrat could have demanded a 60-vote threshold for Justice Thomas. Ted Kennedy did not demand a 60-vote threshold for Justice Thomas. He was confirmed with a simple majority. That, if the Democrats make the ill-advised decision to filibuster next week, will be the rule to which we return, the rule that has governed the Senate and Supreme Court nominations for 2 centuries.
I guess that's the end of it then. Thank you all very much.
Thank you.